The envelope arrived on a Thursday morning in October, and Vera Calloway almost missed it entirely because she was standing at the kitchen counter of the house she no longer legally owned, trying to make sense of a certified letter from a bank she had never opened an account with in her life. If you're enjoying this story so far, don't forget to hit the like button and subscribe. Drop a comment telling me where in the world you're watching from. I love hearing from you. She was 73 years old. She wore her gray hair pulled back the way she had worn it every day for the last 30 years, pinned at the nape of the neck with a tortoiseshell clip her late mother had given her in 1987. She had on her good blue cardigan, the one she had pressed the night before because Thursdays were the days she volunteered at the Millhaven Senior Center, and she had always believed that showing up well-dressed was a form of respect, both for the people you were going to see and for the version of yourself you were trying to remain. The cardigan was a small, deliberate thing. It was the kind of small, deliberate thing Vera Calloway had been holding on to for the past 14 months, since the first time she had understood, truly understood, what her son Marcus and his wife Darlene had done. She set the bank letter down on the counter next to the one from the attorney's office, next to the one from the county property assessor, next to the coffee she had not touched since it went cold an hour ago. She picked up the envelope from the bottom of the stack because it was smaller than the rest and had no official return address, and her name on the front was written by hand in an ink that had bled a little at the edges, the way ink bleeds when it's written with a pen that is almost out. The handwriting was cramped and careful, and she recognized it the way you recognize a sound you haven't heard in years, but remember immediately once it reaches you. It was her father's handwriting, which was not possible. Her father, Raymond Maddox, had been dead for 11 years. She stood at the kitchen counter with the envelope in both hands and felt the cold of the morning through the window glass behind her and did not open it right away. She held it the way you hold a thing that you understand, even before you know what is inside, is going to change the shape of what comes next. She was not a superstitious woman. She had been a bookkeeper for 31 years at the same heating and air conditioning company in Millhaven, Tennessee, and she had spent 3 decades looking at numbers and finding the places where they did not add up, which was a skill that had made her very good at her job and had also made it very difficult for the people around her to hide things from her for long. She was practical and precise, and she did not tend toward the dramatic. But she held that envelope for a long moment before she opened it, because something in the weight of it, and the handwriting, and the particular quality of that October morning told her that she was standing at one of those thin places where before and after press up against each other, and you can feel both sides at once. Inside the envelope was a single sheet of yellow legal paper, folded in thirds, and a small brass key on a loop of red cord. The key was old, not antique old in the decorative sense, but worn old, the kind of worn that comes from years of being carried in a pocket or held in a palm. It was flat-headed with 3 teeth and had the number 114 stamped into the bow in numerals so small she had to hold it close to the window light to read them. The letter was in her father's hand. She read it standing at the counter, her coffee gone cold beside her, the October light moving in slow panels across the floor. It read, "Vera, if this finds you, then I was right to prepare for what I always hoped would never happen. I am writing this in the summer of 2011, and I am asking my oldest friend, Harold Briggs, to hold it until the time comes when he believes you need it. I hope you never need it. I hope Marcus turns out to be exactly the man you believe he is. But I have sat across from that boy at my kitchen table, and I have watched the way he looks at land, and I have watched the way he looks at money, and I am your father, Vera, and I have been watching people's eyes my whole life, and I know what I saw. So I am leaving you this. The key is to storage unit 114 at Millhaven Self-Storage on Route 7. I have kept the rent paid through a separate account that Darlene and Marcus do not know about and cannot touch. Harold will keep paying it as long as need be. What is in that unit is yours, not because I am giving it to you now, but because it was always yours and I should have made that clearer sooner. I am sorry I did not. Go see what your father left you, sweetheart. And do not let anyone tell you it is too late. All my love, Raymond Maddox, July 14th, 2011. Vera read it twice. Then she sat down on the kitchen floor with her back against the cabinet because her legs had made a decision without consulting her, and she held the letter in her lap and looked at the brass key on its loop of red cord and did not say anything out loud because there was no one there to say anything to. The house was quiet around her the way a house is quiet when it belongs to someone else and is only waiting for you to realize it. She had been married to Gerald Calloway for 44 years. He had been an electrician, a steady and unhurried man who had loved crossword puzzles and the Tennessee Volunteers and the particular silence of early mornings before the neighborhood woke up. He had died in the spring of 2019 of a stroke that arrived without warning while he was sitting in the truck in the driveway. And she had found him there when she went out to tell him supper was ready. And she had understood in the first second of seeing him that the shape of her remaining life had just changed entirely. She had not recovered from it the way people say you recover from grief, which is to say she had not stopped feeling it. She had simply learned to carry it differently. She had her volunteer work. She had her neighbor Mrs. Adkins 2 houses down, who came for coffee on Wednesdays. She had her cat, a gray Tom named Figure, who had been Gerald's cat first and had transferred his primary loyalty to Vera with the pragmatic efficiency of a creature who understood that warmth and consistency were more important than sentiment. She had the house Gerald had built for her in 1991 on Sycamore Trace, a 2-story colonial with a covered back porch and a kitchen garden she had been tending for 30 years, and a fig tree Gerald had planted the spring Vera turned 45 because he said every woman deserved a fig tree of her own. She had believed, after Gerald, that she had already met her worst loss. She had been wrong. Marcus was their only child, born in 1974, the kind of boy who had been charming since before he could walk, and who had learned early that charm was easier than effort and had never quite unlearned it. Vera had loved him with the full and slightly anxious love of a mother who sees her child clearly and loves him anyway, which is the hardest kind. Gerald had been more measured. He had said, not unkindly, on more than one occasion, that Marcus would be fine as long as someone else was carrying the weight. He had said it the way honest fathers say uncomfortable things about their sons, quietly, and only to their wives, and only when it was necessary. Darlene was Marcus's second wife, married in 2016 after a first marriage that Marcus had described as a misunderstanding and that Vera had understood, from the one time she met the first wife, was considerably more than that. Darlene was 41 to Marcus's 45, pleasant at holidays, efficient in a way that Vera had initially mistaken for competence and had later understood was calculation. She had the particular smile of a woman who is always doing 2 things at once, and only one of them is visible. It had started small, the way these things always do. A suggestion from Marcus, in the fall of 2021, that perhaps Vera should think about simplifying her finances now that she was on her own. He had sat at her kitchen table with a yellow legal pad and talked about estate planning and tax efficiency and the burden of maintaining a property at her age, and he had used the word streamline 4 times in an hour, which Vera had counted and not remarked upon. She had listened and said she would think about it, and she had thought about it, and she had not done anything, because she was a bookkeeper by profession and she knew exactly what streamlining meant when someone else was doing it with your assets. But he came back. He came back 3 times over the next 6 months, each time with a different approach, a different set of papers, a different version of the same fundamental request. And somewhere in the middle of the 3rd visit, Darlene was there too, and the conversation had shifted in a way that Vera could feel but not quite name. The way a room shifts when the weight in it moves to one side. And before she entirely understood what had happened, she had signed something that she had believed was a healthcare proxy, and that was in fact a durable power of attorney over her financial accounts and her property. She was not a foolish woman. She wanted to say that clearly, to herself, there in the kitchen floor. She was not a foolish woman. She had spent 31 years finding the errors in other people's numbers. But she was a woman who had just buried her husband and who had a son sitting at her kitchen table. And there is a particular kind of trust that a mother extends to her child that bypasses the part of the brain that is good at reading documents. And that trust is not stupidity. It is love. It is love operating in a context where it should have been safe. The power of attorney gave Marcus control of her accounts within 60 days. The deed to the house on Sycamore Trace was transferred to an LLC that Darlene had formed 2 months earlier, a transaction that appeared in the county records as a sale at fair market value, except that the payment had been made from one account to another within the same family structure, and the money had never actually reached Vera. The fig tree Gerald had planted was still in the backyard of a house that now had Marcus's name on the deed, and Vera was still living in it because, As Marcus explained with the pained patience of a man performing reluctant duty, eviction proceedings took time, and he did not want to rush her. She had called an attorney. The attorney had told her the documents were legal. She had called another attorney. That attorney had told her the same thing, but with more sympathy. She had called the county sheriff's office, and a deputy had come to the house and listened carefully and told her it sounded like a civil matter. She had called the state attorney general's consumer protection line and been placed on hold for an hour and 20 minutes, and had eventually spoken to a woman who had taken notes and told her someone would follow up within 30 to 60 business days. No one had followed up. That had been 8 months ago. In the time since, Marcus had stopped calling. Darlene had sent a single text message in June informing Vera that the property would be listed for sale in the spring and that she should begin making arrangements for her living situation, which was a sentence Vera had read 5 times, and each time felt a specific and clarifying kind of anger that she had learned over 73 years to keep very quiet. She was still in the house because the sale had not yet gone through. She was still in the house because she had nowhere to go and because she was not the kind of woman who left a place she had lived in for 30 years without being forced out. Physically, and Marcus, whatever else he was, apparently lacked the stomach to do that directly. She was still in the house, sitting on the kitchen floor on a Thursday morning in October, holding a brass key on a red cord and a letter from her dead father, and understanding, in the particular way that things become clear after a very long time of not being clear, that Raymond Earl Maddox had seen this coming before she had even seen Marcus begin to lean toward it. Her father had been a practical man, a carpenter who had worked for himself for 40 years in Millhaven, building additions and repairs, and the occasional full house for families on the east side of town, and who had saved money with the deliberate consistency of a person who had grown up without any and intended to die with enough to leave something behind. He had owned a parcel of land on the edge of town that had been in the family since his own grandfather's time, 12 acres of good ground on the bluff above Marker Creek, and a separate savings account that he had always referred to simply as the provision, a word he used the way other people used the word insurance, without drama and without further explanation. He had died in 2013 at the age of 81, clear-minded until the last week, surrounded by the particular disorder of a man who had always known where everything was even when it appeared that no one else possibly could. His will had been simple. The land on the bluff, which had been appraised at just under $200,000, had gone to Vera. The provision account, which had turned out to contain $63,000, had been divided equally between Vera and her younger brother Dale. The house Raymond had lived in had been sold to settle a small remaining mortgage, and the proceeds had gone to cover the funeral and the outstanding medical bills, and there had been nothing left after that, which was what Raymond had intended. Vera had put the land in her own name. Gerald had been alive then, and healthy, and they had driven out to the bluff together one Sunday afternoon in the spring after the estate was settled, and stood at the edge of it looking out over Marker Creek and the town below, and Gerald had put his arm around her and said, simply, that her father had done right by her, and Vera had agreed. She had not thought about the land much after that. It was not something she could farm or build on easily, and they did not need the money from selling it. And so it had simply been there, the way inherited land tends to be, present and accounted for, and not immediately relevant. Then Marcus had begun his streamlining, and Vera had made the mistake of mentioning the land in passing during one of those kitchen table conversations, because she had not yet understood what the conversations were actually about, and that mention had lodged somewhere behind Marcus's eyes in a way she had noticed and immediately forgotten, and then, 14 months later, remembered with absolute clarity. The land on the bluff above Marker Creek had been transferred out of Vera's name in the same transaction that had taken the house. The same LLC, the same documentation, the same signature, her signature, on a deed transfer that she had not signed. She had not signed it. She was certain of this the way she was certain of very few things remaining in her life, with the full and irreducible certainty of a woman who had spent 31 years knowing exactly what her own signature looked like and what it meant when it appeared on a document. She had told the second attorney this. The attorney had looked at the document carefully and said that the signature was very close. Vera had said that close was not the same as real. The attorney had agreed with her in principle and then explained, in the careful language of someone describing a wall you cannot climb, that proving signature fraud in a civil context required expert testimony and forensic analysis and a level of documentation that would make the litigation expensive and prolonged and not guaranteed. Vera had thanked the attorney and paid the consultation fee and driven home and sat in the kitchen and looked at the fig tree through the window and understood, for the first time in her life, what it felt like to have been entirely and deliberately erased from your own story. And then, for weeks after that, the envelope had come. With the key, with the red cord, with her father's handwriting, blood at the edges, careful and cramped and unmistakable. She got up from the kitchen floor. She brushed off the back of her good blue cardigan. She poured the cold coffee down the drain and put the cup in the dish rack and picked up the brass key and put it in her cardigan pocket where she could feel the weight of it against her ribs. She fed Figure, who had been sitting at the edge of the kitchen watching her with the patient attention of a cat who has decided that whatever the human is doing, it can wait. She put on her coat. She called Harold Briggs from the car. Harold was 84 years old and had been her father's closest friend for 60 of those years, a retired postmaster who lived alone in the house he had bought in 1969 and who had, in all the years Vera had known him, never once said a thing he did not mean. He answered on the second ring. He said he had been waiting for this call for a while. He said he was sorry it had taken this long to send the letter, that he had been watching from a distance, trying to determine the right moment, and that when he had heard through Mrs. Adkins about the deed situation, he had understood the moment had come. He said Raymond had told him, the summer he wrote the letter, that there was something at that storage unit that Vera would need, and that the need would be clear when it came. He said he did not know exactly what was in it. He said Raymond had packed it himself and paid Harold a flat sum to maintain the rental and keep the key until the time arrived. He said Raymond had told him two things about what was inside, that it was old, and that it was important, and that Vera would know what to do with it. Vera drove to Millhaven Self-Storage on Route 7. It was a low concrete complex at the edge of town, the kind of place that had been there long enough to become invisible to the people who passed it every day. The access gate took the code she got from the manager without complaint. She drove slowly through the numbered rows, past the corrugated metal doors with their padlocks and their varying states of rust, past the unit where someone had left a child's bicycle leaning against the door in a way that suggested it had been left temporarily and had become permanent. Unit 114 was at the far end of the last row, set slightly apart from the others at a corner where the concrete apron was shaded by a single old oak that had grown up beside the fence. The padlock on the door was the same age as the key. She could see that from 10 feet away, the matching patina, the same quality of use. Her father had bought them together and kept them together for 11 years through Harold Briggs, which was the kind of thing Raymond Earl Maddox did when he was serious about something. She put the key in the lock. It turned on the first try. She stood with her hand on the rolling door for a moment, with the October light behind her and the particular smell of old concrete and cool air coming through the gap, and she felt her father's presence so strongly and so specifically that she had to press her lips together and breathe carefully through her nose before she could continue. Then she pulled the door up. The unit was 12 by 20 feet, and it was full. Not carelessly full, not the chaos of a life packed in a hurry, but organized with the deliberate precision of a carpenter who had spent his life understanding that things kept properly last, and things kept carelessly do not. Shelving units lined both walls, built from lumber she recognized as the same pine her father had used in his workshop, fitted together with the clean joinery that had been his signature. The shelves held boxes, labeled in her father's hand. Tools, survey maps, tax records, and along the back wall, taking up a full third of the unit, covered in canvas tarpaulins that had been carefully draped and weighted at the corners, were filing cabinets. 4 of them, old, steel, the kind with the deep drawers and the locking bars that ran the full height. And on the center shelf, at eye level, sitting alone and uncovered, a single wooden box about the size of a shoebox, with her name written on the top in her father's hand. She crossed the concrete floor and picked it up and opened it. Inside was a folded letter, a set of photographs, 3 sealed envelopes marked with dates spanning from 1978 to 2009, and at the bottom, beneath all of that, a document she recognized immediately by its format and its government seal, because she had seen documents like it in her years as a bookkeeper. had processed payments related to documents like it for clients who owned mineral rights and timber rights and the various other forms of invisible ownership that attached themselves to land. Like roots to stone, it was a mineral lease agreement, executed in 1978, on land described in the legal description at the top of the page as 12 acres on the bluff above Marker Creek in Millhaven, Tennessee. And at the bottom, in the signature line, was not her father's name. It was hers. Her name, Vera May Maddox, age 28, as she had been in 1978, before she was Vera Calloway. Her name and her signature, on a mineral lease that had been executed in her name and on her behalf by her father, Raymond Earl Maddox, acting as her authorized representative, on the 22nd day of March, 1978. She stood in the middle of storage unit 114 in the October light with the document in both hands, and understood that the 12 acres on the bluff above Marker Creek had never simply been land. She understood that her father had known this, and had not told her, and had spent the last years of his life making sure that when the time came, she would be the one standing in front of whatever it meant. She did not yet know what it meant, but the filing cabinets along the back wall were full of something, and her father had carried it here and kept it for her, and she was a bookkeeper, and she was very good at reading what numbers contained. She pulled the canvas off the first cabinet and opened the top drawer. It was filled, front to back, with royalty statements, dated from 1979 through 2012, from a company she had never heard of, for a resource she had not known was there. Her father had been collecting royalty payments on her behalf for 33 years, and he had saved every statement, and he had never spent $1 of it, and it was all in the filing cabinet, and she was the only person in the world who had the key. She sat down on the concrete floor of the storage unit, in the shadow of the oak tree, with the files in her lap, and she began to read. The royalty statements were organized by year, each one held together with a binder clip and filed in sequence from January through December, the way a careful man files things when he intends for someone else to find them and understand them without assistance. Raymond Earl Maddox had been meticulous in life, and he had been meticulous in this. Vera sat on the concrete floor of storage unit 114 with the first drawer open beside her and worked through the files the way she had spent 31 years working through ledgers, methodically and without rushing, because rushing was how errors got made, and she could not afford errors now. The earliest statements were from 1979. The company name on the letterhead was Crestline Mineral Partners, a Tennessee limited partnership with an address in Nashville that she did not recognize. The statements were formatted the way royalty statements always were: a production figure, a rate, a gross amount, and a net payment after the standard deductions. The resource listed was natural gas. The rate in 1979 was 11 cents per 1,000 cubic feet, which even then had been below the going market rate, and the monthly production figures in those first years were modest. The net payments ranged between $40 and $90 a month, the kind of amount that a person could overlook if they were not paying attention, the kind of amount that a company might set deliberately low in the early years of a lease to avoid attracting notice. She noted this. She set the 1979 file on the floor beside her and opened 1980. The production figures had increased. The rate had not. The net payments were running between $110 and $160 a month by the end of that year. Still not dramatic. Still the kind of number that could be absorbed into the background of a life without comment. She worked through the decade. By 1985, the monthly payments were averaging $240. By 1988, they had crossed $300. The production figures climbed steadily each year, and the rate climbed marginally, always below market, always adjusted in Crestline Mineral Partners' favor in a way that was technically legal and structurally exploitative, and that a person who was not a bookkeeper might not immediately recognize for what it was. Her father had recognized it. She could see that in the margins. Raymond had annotated the statements in pencil, light and precise, in the margins where the statements left white space. He had written the current Tennessee market rate for natural gas beside the rate Crestline was paying. He had written the difference. He had, in some years, written a single word beside the differential, low. In other years he had written the word again, still low. In 1991 he had written, in slightly heavier pencil than the rest, the phrase check on this. And she understood from the weight of those 3 words that he had, in fact, checked on it. She found the evidence of what he had checked on in the sealed envelope marked 1992, which was one of 3 dated envelopes she had found in the wooden box on the center shelf. Inside the 1992 envelope was a letter from a Nashville attorney named Gretchen Parrish, addressed to Raymond Earl Maddox, dated March of that year. The letter was 3 pages long, and she read every word of it standing up, because her legs had decided that what the letter contained required standing. Gretchen Parrish had been a minerals and energy attorney with a firm called Parrish and Bowl, and her letter to Raymond was a formal legal opinion on the lease agreement he had provided for her review. The opinion was careful and thorough, and it said, in the measured language of a careful attorney, 3 things that Vera read twice each to be certain she had understood them correctly. The first was that the lease agreement executed in 1978 on behalf of Vera Mae Maddox was valid and binding, that it had been properly executed under Tennessee law, with Raymond acting as authorized representative, and that the royalty payments flowing from it were legally Vera's property and had been since 1979. The second was that the rate being paid by Crestline Mineral Partners was, in Gretchen Parrish's professional opinion, significantly below fair market value for the production volume and the quality of the formation being tapped, and that this discrepancy had likely been built into the original lease terms deliberately by the lessee, who had clearly understood the value of what lay beneath the bluff above Marker Creek better than the lessor had at the time of signing. The third was the one that made Vera reach out and put her hand on the nearest shelf to steady herself. The formation beneath the bluff above Marker Creek was not a modest pocket of natural gas. It was the eastern edge of a formation that Gretchen Parrish described as significant, a word she used twice and underlined once, that extended across a substantial area of the county and that had been quietly and methodically developed over the preceding decade by Crestline and its parent companies in a way specifically designed to avoid triggering the kind of public attention that might lead the landowners above it to understand what they were sitting on. Raymond had written in the margin beside this paragraph, in pencil, without annotation, Vera does not know. And then, below that, in the same pencil, in letters slightly larger than the rest, she will. Vera stood in the storage unit with the letter in her hands and looked at her father's handwriting in the margin and felt the particular grief of understanding a person more clearly after they are gone than you ever fully managed while they were present. He had known. He had carried this for 20 years, this knowledge of what lay beneath the land he had saved for her, and he had not told her because he was a cautious man and he had not yet understood the full shape of it himself. And then he had gotten old, and time had moved the way it does, and he had died before he found the right words. And so he had done the next best thing, which was to make sure that when she finally needed to know everything she needed to understand, it was waiting for her in a room, with a locked door and a key on a red cord. She opened the filing cabinet for 1992 and picked up where she had left off. The payments had grown through the 90s. By 1995, they were averaging $800 a month. By 1998, $1,100. By 2003, which was when the formation appears to have entered its most productive period based on the production figures she was reading, the monthly payments had climbed to just over $3,000, which meant that in 2003 alone, Crestline Mineral Partners had paid out $36,000 in royalties on the Maddox parcel, at a rate, she noted, that Gretchen Parrish had identified as significantly below market value over a decade earlier. Her father had kept every dollar. She could see it in the second sealed envelope, the one marked 2005, which contained a statement from a credit union in Nashville where Raymond had opened an account in Vera's name in 1979 using the documentation from the lease agreement and into which he had deposited every royalty payment for 26 years. The account statement for December 2005 showed a balance, with compounded interest at the rates the credit union had paid through those decades, of $412,000. She sat down again. She sat on the concrete floor with the December 2005 statement in her lap and figure's absence very present beside her, the way animals are present even when they are not there, and she breathed carefully and looked at the oak tree through the open door of the storage unit and listened to a car pass on Route 7 and did not say anything out loud because there was still no one there to say it to. $412,000 in 2005. And the payments had continued through 2012, the last year in the filing cabinet, at rates that had climbed as gas prices climbed in the late 2000s. She pulled the 2012 file. The monthly payments that year ranged from $4,000 to $6,000, depending on production. Her father had died in 2013. Harold Briggs had continued paying the storage rental. The credit union account, if it had remained open, had continued receiving deposits. She had no way of knowing, sitting on this floor, what the current balance was. But she was a bookkeeper. She could estimate. She pulled a small notebook from her coat pocket, the one she kept for grocery lists and appointment reminders, and she turned to a blank page and began writing down figures. The deposits she could calculate from the statements. The interest rate the credit union had paid, which was printed on each annual statement. The approximate continuation of payments through 2012. She worked through it the way she worked through anything numerical, without hurry, following each figure to its consequence. When she finished, she looked at what she had written, and then she looked at the oak tree again, and then she looked at the number again. If the account had remained open and the royalties had continued at even a modest rate through the current year, the balance would be somewhere between $900,000 and $1.2 million. Depending on production and rate adjustments, she could not calculate without the statements from 2013 forward. She was sitting on the floor of a storage unit her dead father had maintained for 11 years after his death, through his oldest friend, specifically so that the money Marcus and Darlene had stolen from her would not be the end of her story. She closed the notebook. She stood up. She put the December 2005 statement carefully back in its file and closed the filing cabinet drawer and stood for a long moment in the center of the unit, looking at what Raymond had built for her in this room. The shelves and the boxes and the files and the careful labeled order of a man who had understood that preparation was a form of love. Then she pulled out her phone and called Harold Briggs back. Harold listened without interrupting while she described what she had found. When she finished, there was a silence on his end that lasted long enough that she asked if he was still there. He said he was. He said he was glad. He said he had wondered, over the years, exactly what was in those cabinets, and that he had trusted Raymond's judgment enough not to ask, and that what she was describing sounded like exactly the kind of thing Raymond would have done, which was to say it was thorough, and it was quiet, and it had waited until the right moment with the patience of someone who understood that the right moment always came eventually. He said there was one more thing. He said Raymond had given him, in addition to the rental payments and the key, a name. He said he had been instructed to give Vera the name when the time came, when she had found the unit and understood what was in it. He said the name was Gretchen Parrish, and that Raymond had told him she was the best minerals attorney in Tennessee, and that she was the person Vera needed. Vera said she had already found Gretchen Parrish's letter in the 1992 envelope. Harold said that sounded like Raymond. Harold said that Raymond had never once done anything that had not already been done twice in his own mind before he did it. She thanked Harold. She told him she would keep him informed. He said he would appreciate that, and that he was 84 years old and would appreciate being kept informed with some promptness, which was the closest thing to a joke Harold Briggs had ever made in her presence, and she understood it for what it was, which was love of a specific and elderly kind, practical and a little urgent. She spent another hour in the unit that afternoon, not reading but inventorying. She counted the filing cabinets. She opened each one briefly and confirmed their contents. She found, in the third cabinet, a folder she had not expected, labeled in her father's hand with a single word, survey. Inside were 4 professional land surveys of the 12 acres on the Bluff, dated 1977, 1985, 1998, and 2009. Each survey had been done by a different firm. Each one covered not only the surface boundaries of the parcel, but the subsurface geology, annotated with formation depths and production zone identifications that she could read well enough to understand that whoever had done these surveys had known exactly what they were measuring and why. Her father had commissioned 4 geological surveys of his daughter's land over 30 years. He had never mentioned a single one of them. In the 4th cabinet, behind the survey folder, was a legal-size folder labeled Simply Lease. Inside was the original lease agreement from 1978, the one she had found a copy of in the wooden box. But this was the original, with the original signatures, and behind it was something the copy had not contained, an addendum, for pages stapled to the back of the lease, executed in 1989, that she had to read 3 times because the language was dense and the implications took a moment to arrive fully. The addendum was a right of renegotiation clause. It stated that upon the death of the primary lessor's authorized representative, meaning Raymond, or upon the lessor's written request at any time after January 1st, 2000, the royalty rate would be subject to mandatory renegotiation based on current market rates, and that during the renegotiation period, payments would be held in escrow rather than disbursed, and that any failure to renegotiate in good faith within 90 days would constitute a breach of the lease terms, triggering a reversion of all mineral rights to the lessor. Raymond Maddox had negotiated this clause into the lease in 1989, 11 years before it could be exercised. He had sat across from someone from Crestline Mineral Partners in 1989, and he had had a lawyer with him, because the clause had a signature from an attorney she did not recognize, and he had gotten this language into the agreement, and he had never told anyone. She stood in the fourth cabinet's drawer with her hand on the addendum, and she understood that her father had not simply saved her money. He had saved her a mechanism. He had saved her the legal right to demand that Crestline renegotiate the terms of a lease that had been underpricing her mineral rights for 45 years, and to hold their payments in escrow until they did it, and to reclaim the rights entirely if they refused. He had built her a door, and then he had locked it, and then he had given the key to his oldest friend and waited. She photographed every page of the addendum with her phone. She photographed the 4 surveys. She photographed the December 2005 account statement and the 1992 letter from Gretchen Parrish and the original lease agreement. She spent 40 minutes photographing, and she was thorough because she was always thorough. And when she was done, she rolled the storage unit door down and drove back through Millhaven with the brass key in her cardigan pocket and figure waiting on the porch of a house that did not belong to her. She fed the cat. She made the coffee she had not had that morning. She sat at the kitchen counter that would belong to someone else in the spring, and she looked out the window at the fig tree Gerald had planted, and she did not think about Marcus. She thought about her father, 30 years old in 1948, building furniture in the small workshop behind his parents' house in Millhaven, learning the grain of wood and the patience that would required, becoming the kind of man who understood that what you built for other people outlasted everything else. She thought about him at 48, standing across a conference table from someone from Crestline Mineral Partners, with a lawyer beside him and a lease amendment in his hand, saying nothing except what the document said, because a careful man does not need to say more than what is written down. She thought about him at 70, sitting at the kitchen table in his own house on a July evening in 2011, writing a letter in a hand that was starting to show its age, writing sweetheart, which he had not called her in years, writing it because the distance between the letter and the reader was going to be 11 years and some tenderness was required to cross it. She did not cry. She was saving it. She had learned over 73 years that tears spent too early are not available when you need them most. If you're hooked on this story, make sure to subscribe and turn on notifications so you never miss an upload. Your support means everything and helps me bring you more emotional stories like this one. She found Gretchen Parrish through the Tennessee Bar Association website that evening. Gretchen Parrish was 71 years old and still practicing, still at a firm in Nashville, no longer called Parrish and Bull, but now Parrish Kendall, with 4 attorneys listed on the website and a specialization page that listed mineral rights, energy law, and royalty disputes as the firm's primary areas. Her photograph on the website showed a woman with close-cropped white hair and reading glasses pushed up on her head, and the expression of someone who had seen a great many things that had not surprised her and had remained interested anyway. Vera sent an email that night. She kept it brief the way her father would have kept it brief. She said her name and her father's name, and that she had found a letter from Gretchen Parrish in her father's files dated 1992 pertaining to a mineral lease on a parcel in Millhaven. She said she believed the situation had developed considerably since 1992 and that she would like to speak with Ms. Parrish at her earliest convenience. She attached photographs of the 1992 letter, the original lease, the addendum, and the December 2005 account statement. Gretchen Parrish called her at 8:15 the following morning. She said she remembered Raymond Maddox. She said she had not thought of him in years, and that hearing his name was like opening a window in a room that had been closed for a long time. She said he had been the most prepared client she had ever worked with, and that she had spent 30 years saying that about him because it was true and because she believed that precision deserved to be named. She said she had reviewed the photographs Vera had sent and that she needed to see the originals, all of them, as soon as possible, and that she was going to clear her Friday for this. Vera drove to Nashville on Friday with the wooden box and the key and 3 of the most important files from the cabinets in the back seat of Gerald's old truck, which she had kept because it was paid for and reliable, and which still had one of his crossword puzzle books tucked in the door pocket where he had left it in the spring of 2019. She parked in the garage beneath Parish Kindle's building and rode the elevator to the 4th floor and was shown into a conference room where Gretchen Parish was already seated with a yellow legal pad and a pen and a cup of coffee and the particular stillness of a person who had learned to give their full attention to whatever was in front of them. They shook hands. Gretchen looked at her the way she had looked in her website photograph, directly and without performance. She said she was sorry about what Vera's son had done. She said it clearly and without hedging, as a fact she had already established from the photographs, and Vera appreciated the directness because she was tired of people being careful around the edges of it. They spread the documents across the conference table and Gretchen went through them in the order Vera had organized them, which was chronological, which was the only order that made sense. She read slowly. She turned pages with care. She asked 3 questions in the first hour, each one precise and each one pointing at the thing Vera had herself identified as the critical leverage point. When she reached the addendum, she stopped and read it twice without looking up, and then she set it down and took off her glasses and looked at Vera across the table. She said that Raymond Maddox had been a very unusual man. She said she had told him so in 1989 when he had come to her office with the original lease and a handwritten list of things he wanted changed before he would agree to the renegotiation of the term structure, and that she had told him the right of renegotiation clause was an extraordinary thing to ask for, and that Crestline would push back. And he had said he understood they would push back, and that he was prepared to wait as long as necessary, and that he had waited 14 months before. Crestline's attorney had finally agreed to the language. She said that in 35 years of minerals law she had seen a great many lease agreements, and that the right of renegotiation clause Raymond had negotiated was among the most foresight provisions she had encountered in a private lease of that era. She said it had been inserted at exactly the right moment in the development of the formation, before the full production potential had become publicly apparent, and that Crestline had agreed to it because they had believed at the time that the renegotiation trigger was distant enough and the conditions specific enough that it would never be exercised. She said that it could now be exercised. She said that Raymond's death in 2013 had technically triggered the right of renegotiation under the terms of the addendum, and that no renegotiation had occurred, and that this meant Crestline had been in technical breach of the lease terms for 11 years. During which time they had continued to pay royalties at the 1978 rate into an account they had no reason to believe was anything other than correctly managed. She said that the remedies available under the breach clause were significant. Vera asked her to be specific about significant. Gretchen said that a formal breach notice would require Crestline to either renegotiate the royalty rate to current market value within 90 days or face the reversion clause, which would transfer all mineral rights back to the lessor. She said that the current market value royalty rate for the formation in question, based on production figures she could access through public records, would represent an increase of approximately 400% over what had been paid. She said that a reversion of mineral rights would give Vera the option of leasing the formation again at current market rates or of selling the mineral rights outright, and that the current value of the mineral estate beneath 12 acres of productive formation in that part of Millhaven County would be assessed, conservatively, at somewhere between $2 and $4 million. Vera was quiet for a moment. She asked about the forged deed. She asked about Marcus and the LLC and the transfer of the surface rights to the parcel. Gretchen said that this was where it became complicated and also where it became interesting. She said that in Tennessee law, surface rights and mineral rights were separable estates, which was standard across most of the country, and that the mineral lease predated the deed transfer by 45 years, and that any transfer of surface rights to the parcel did not and could not extinguish a mineral estate that had been properly recorded and was prior in time. She said that whatever Marcus had transferred to his LLC was the surface, the dirt and the grass, and whatever sat on top of it. She said he did not own what was underneath it. She said furthermore that the question of whether the deed transfer itself was valid, given Vera's statement that her signature had been forged, was a separate legal matter that she was not a litigator and could not handle directly, but that she had a colleague in Nashville named James Wilder who handled elder financial exploitation cases and who was, in her professional assessment, the best litigator in Tennessee for exactly this kind of situation. She said she would call James Wilder today. She said Raymond Maddox had done something remarkable. She said that he had understood, decades before anyone else in the story, that the value of the land was not what sat on top of it, and that the people who might eventually try to take that surface value from his daughter would not think to look beneath it, because people who take things quickly and quietly are never looking for what requires patience to find. She said he had built Vera a floor below the floor they had taken. Vera sat in the conference room of Parish Kendall on the 4th floor of a building in Nashville and looked out the window at the city her father had driven to 35 years ago with a list of things he needed in writing, and she thought about the pencil marks in the margins of the royalty statements. That low? Still low? Check on this. And she felt the full weight of what it meant to have been loved by someone who had expressed that love in the only language that was going to survive him, which was the language of preparation. She said yes to James Wilder. She said yes to the breach notice. She said yes to Gretchen beginning the mineral rights valuation process immediately. Then she drove back to Millhaven in Gerald's truck with the crossword book in the door pocket and figure waiting on the porch and the fig tree in the backyard of a house that had her name nowhere on its deed, and the brass key in her cardigan pocket, and the very particular and quiet knowledge that the ground beneath everything Marcus had taken was still entirely hers. James Wilder called her the following Monday. He was younger than she had expected from a name that sounded established, 43, with a direct manner and the focused economy of someone who had learned to be efficient with time because the cases he worked tended to be urgent and the people in them tended to have been waiting too long already. He said Gretchen had briefed him. He said he had looked at the county records over the weekend. He said the deed transfer to Marcus's LLC had 3 problems that he could see from the public filing alone, and that he would need to see the original documents to identify the rest. He drove to Millhaven the following Wednesday. He sat at the kitchen counter where Trent Schaefer's documents had once been spread, which was not the same kitchen counter, but was close enough in the landscape of Vera's mind. And she put her father's files in front of him, and he went through them with the same careful attention Gretchen had given them and asked different questions, pointed in different directions, toward different pressure points. He said the signature on the deed transfer was irregular in 3 ways he could identify without a forensic expert, and in at least one way that would require one. He said that the power of attorney Vera had signed, which she had believed was a healthcare proxy, was potentially challengeable on the grounds of fraudulent inducement, which was a legal theory that required demonstrating that the signer had been deliberately misled about the nature of what they were signing. He said that the use of an LLC to receive a fraudulent transfer was itself a separate cause of action that could pierce the corporate structure and reach Marcus personally. He said that elder financial exploitation in Tennessee carried both civil and criminal exposure, and that the criminal exposure was a matter for the district attorney's office, which he would be contacting separately. He said he would take the case. He said he worked on contingency in elder exploitation matters because he believed that the contingency arrangement was the only one that aligned his interests with his clients in the way the law was supposed to work. He said he did not need a retainer. He said he needed the original documents, a written statement from Vera about each transaction she had been party to, and the name of the attorney who had told her the documents were legal, because he had thoughts about that. She gave him everything he asked for. She made him a cup of coffee. He drank it and thanked her and looked out the window at the fig tree and asked about it, because it was October and the tree still had leaves and looked healthy, which was not something you always saw in a fig that old. She told him Gerald had planted it. He nodded in the way people nod when they understand that a tree is not just a tree. He left at 2 in the afternoon with her files and her statement and a copy of the key documentation from the storage unit, which she had already made 3 copies of and stored in 3 separate places, because she was a bookkeeper and she understood that the most important documents in the world were only as safe as the number of copies that existed. She stood on the porch of the house that did not belong to her and watched James Wilder's car disappear down Sycamore Trace and felt, for the first time in 14 months, the specific and grounded relief of having put something in the hands of someone who knew what to do with it. Not hope exactly. Not yet. Hope required a future she could not yet see, but something adjacent to it. Something that felt like the first shift of a door that has been sealed for a very long time beginning, just barely, just at the edges, to move. Figure came out and sat beside her feet and looked at the empty street and flicked his tail once. She went inside and made supper. The breach notice went to Crestline Mineral Partners on a Tuesday morning in November, delivered by certified mail to their registered Nashville office and to the office of their corporate counsel simultaneously, because James Wilder was the kind of attorney who understood that important letters needed to arrive in more than one place at once. The notice was 4 pages long and cited the 1989 addendum by section and paragraph, documented the 11 years of noncompliance following Raymond's death, and stated clearly and without drama that Vera Calloway, formerly Vera Maddox, as the lawful lessor of record, was exercising her right of renegotiation and demanding a response within 90 days. Gretchen Parrish filed the mineral rights valuation petition with the county the same week. The petition triggered a public notice requirement, which meant that within 10 days, a small legal announcement appeared in the Millhaven Courier in the Property Notices section on page 8, the section that almost no one read, and that Marcus Calloway apparently did not read either, until a colleague of his who handled commercial real estate called him on a Thursday afternoon and asked, in a careful and curious voice, whether Marcus was aware that his mother had filed a mineral rights action on a parcel in his LLC's name. James Wilder told Vera about that call secondhand, through the colleague who had then called the county clerk's office to request the petition documents and whose request had been noted and reported. He told her with the measured satisfaction of someone describing an expected outcome that had arrived on schedule. He said Marcus would be talking to an attorney by the end of the week. He said that was fine. He said that was, in fact, exactly what he had been waiting for. The civil complaint for elder financial exploitation, fraudulent deed transfer, and forgery was filed in Millhaven County Circuit Court on the first Monday of December. It was 41 pages long, and it named Marcus Calloway and Darlene Calloway individually and their LLC as defendants. It included the forensic document examiner's preliminary report, which James had commissioned in October from an examiner in Memphis who had spent 22 years doing this work for federal courts and who had identified, in her report, 7 specific irregularities in the signature on the deed transfer that distinguished it from the authenticated samples of Vera's actual signature taken from 30 years of tax documents, bank records, and legal filings. The examiner's conclusion, stated in the flat and unsparing language of a professional who did not soften findings for anyone's comfort, was that the signature on the deed transfer had not been written by Vera Calloway. The complaint also included the power of attorney document, with a detailed analysis by a second expert, a fraud specialist from Vanderbilt's law school clinic, demonstrating that the document Vera had signed had been modified after her signature was obtained. That specific language had been inserted into the body of the power of attorney after the fact in a font and ink that were marginally but measurably different from the surrounding text, and that the healthcare proxy Vera believed she was signing had never existed as a separate document. The district attorney's office in Millhaven County opened a criminal investigation the same week the civil complaint was filed. James had provided them a copy of everything 2 weeks earlier, because he believed that the civil and criminal processes worked best when they ran in parallel and when the people conducting the criminal investigation had the same complete picture he did. Vera was in the storage unit on the day the complaint was filed, not because she needed to be, but because she had taken to going there on significant days. She had spent the weeks since the first visit organizing the cabinets properly, the way they deserved to be organized now that she understood what they contained, and she had brought a folding chair and a small lamp, and she worked in the quiet of the unit the way she had worked for 31 years, carefully and without hurry. And she found it peaceful in a way she could not entirely explain except that it was the room her father had built for her, and it felt like being in his company. She was there when her phone showed a text from a number she did not recognize that said simply, "We should talk." She knew from the area code it was Marcus. She forwarded it to James and did not reply. Crestline Mineral Partners responded to the breach notice on day 87 of 90. Their response was not a refusal. It was a request for a meeting, which Gretchen had told Vera to expect, because companies in Crestline's position always requested a meeting before they committed to anything in writing. The meeting was held in Nashville in the same conference room where Vera had first sat across from Gretchen. Except this time there were 4 people on Crestline's side of the table, their general counsel and 3 attorneys from a firm Vera did not recognize, and 2 people on Vera's side, Vera and Gretchen, and the wooden box sat on the table in front of Vera the way it had sat at every meeting, because it had her father's fingerprints on it in a way she could not see but could feel, and that steadied her. Crestline's general counsel was a man in his 60s named Aldrich who had the tired precision of someone who had spent a career cleaning up problems that other people had created. He said Crestline took the renegotiation request seriously. He said they recognized the validity of the 1989 addendum. He said they were prepared to discuss revised terms. Gretchen said they were not there to discuss. She said the 90-day renegotiation window had been triggered 11 years ago and had not been honored, and that Vera was within her rights under the breach clause to elect reversion rather than renegotiation, and that the purpose of this meeting was for Crestline to make an offer sufficient to persuade her client to choose renegotiation instead. Aldrich looked at his attorneys. One of them wrote something on a notepad and slid it across. Aldrich looked at it, and then looked at Vera, not at Gretchen, at Vera, the way people look when they are trying to read what a person actually needs rather than what their attorney has prepared them to say. He said Crestline was prepared to offer a renegotiated royalty rate of 22% of gross production value, retroactive to the date of Raymond's death in 2013, with a lump sum settlement for the 11 years of underpayment at the renegotiated rate, and a continuation of the lease on the new terms for an initial period of 20 years. Gretchen wrote the number on her legal pad without expression and slid it to Vera. The retroactive settlement figure, based on production records Gretchen had pulled from public filings, was $1.4 million. The ongoing royalty at 22% of gross, based on current production, was approximately $18,000 a month. Vera looked at the number for a moment. Then she looked at Aldrich and said she wanted one additional term. She said she wanted a permanent public notation in the county mineral records acknowledging that the mineral estate on the Maddox parcel had been held by Vera Calloway as original lessor of record since 1978, and that no subsequent surface transfer had affected or diminished that estate. Aldrich looked at his attorneys again. The attorney with the notepad nodded. Aldrich said yes. Gretchen drafted the term sheet before they left the building. The civil case did not go to trial. Marcus Calloway's attorney contacted James Wilder in January with an opening settlement position that James described to Vera as optimistic on Marcus's behalf. James responded with a counter that he described as realistic. They negotiated for 6 weeks, during which time the district attorney's office informed Marcus through his criminal defense attorney that the criminal investigation had produced sufficient evidence to proceed to a grand jury. That information arrived in Marcus's civil settlement discussions with a predictable effect on his willingness to compromise. The civil settlement was reached on a Wednesday in late February. The LLC was dissolved. The deed to the house on Sycamore Trace was transferred back to Vera's name. The deed to the 12 acres on the Bluff was transferred back to Vera's name. Marcus and Darlene paid restitution for the 14 months of mortgage payments they had collected by renting the house through a property management company without Vera's knowledge, a fact James had uncovered in the discovery process that had added a separate damages claim to the complaint. The total restitution figure was $214,000, which covered the house rental income, legal fees, and a judgment for pain and suffering that the mediator had set at a number that made Marcus's attorney's face do something complicated when she read it aloud. The criminal case resulted in a guilty plea in April. Marcus pleaded to elder financial exploitation and forgery, 2 counts each. The plea agreement resulted in 5 years of supervised probation, community service, and a permanent notation on his record that would follow him through every professional and financial background check for the rest of his working life. Darlene pleaded to a single count of fraud and received 3 years of probation. Vera was not in the courtroom for the plea. She was at the storage unit, sitting in her folding chair with the lamp on and a cup of coffee from the thermos she now brought with her, going through the last of the filing cabinets. Not because there was anything left to find. She had found everything. But because the room was her father's room and she was in no hurry to stop spending time in it. She had decided what to do with the unit itself. She was going to have the shelving dismantled carefully, the lumber cleaned and preserved, and the filing cabinets moved to the house on the Bluff she had decided to build on the 12 acres above Marker Creek. Not a large house. Something modest and well-made, with a covered porch and a kitchen window that caught morning light, and a room for figure, and a room for whatever she decided to do with the years she had left. She was going to plant a fig tree. She had already selected the variety, a brown turkey, hardy to Tennessee winters and reliably productive from the second year, because she was 73 years old and did not have the patience for a variety that made you wait 5 years for the first figure. The credit union account in Nashville, the one Raymond had maintained since 1979, had a current balance. When Vera finally called and produced the documentation Gretchen had helped her prepare, of $1,088,000. The credit union's compliance officer, a young woman named Sonia, told Vera that the account had been flagged for dormancy review 3 times over the preceding decade, but had each time been kept active because Harold Briggs's rental payments had technically qualified as related account activity. Vera thanked her. Sonia said she was sorry for whatever Vera had been through to arrive at this phone call. Vera said she was not as sorry as she might have been before today. Sonia laughed, surprised, and Vera thought that was a very healthy response. She drove to Harold Briggs's house on the other side of Millhaven with a check for $50,000 and a pecan pie she had made herself, because she did not know how else to thank a man who had paid a storage rental every month for 11 years for a friend who was already gone. Harold accepted the check with the quiet dignity of someone who had done the thing because it needed doing and had not counted on being compensated. He held the pie with both hands and said that Raymond would have been very pleased with how this had come out. He said Raymond had told him once, 5 years before he died, that a woman who knew about the floor beneath her would walk differently on the one above it. He said he had wanted Vera to walk on her own floor freely for as long as she could, without the weight of knowing what was underneath, and that the weight would only be useful when someone tried to take the floor away. Harold ate a piece of the pie while she sat with him, and they talked about Raymond for an hour. The way you talk about people who are gone when you are finally in a place where the talking feels like celebration rather than loss. She drove home along Route 7 past Millhaven Self-Storage and did not stop, because there would be other days for that, and she was not in a hurry. She drove past the turn for Sycamore Trace and continued on to the Bluff Road, the unpaved track that wound up through the cedar scrub to the 12 acres that had been in her family since before she was born, and she drove to the top and parked and got out in the late afternoon light and stood at the edge looking out over Marker Creek and the town below. The light was the particular amber of late winter in Tennessee, the kind that makes everything look simultaneously old and new, like something being remembered and discovered at the same time. The formation beneath her feet was still there, as it had always been there, patient in the way that things underground are patient, unchanged by the transactions conducted above them, indifferent to the taking and the forgiving and the long, slow work of coming back to themselves. She stood there until the light began to go. Then she got back in the truck and drove down the Bluff Road toward town, toward the house with the fig tree, toward figure on the porch, toward the life her father had kept sealed for her below the life everyone else thought they had taken. He had been right, as he had usually been right about the things that mattered. She walked differently now. Not better, not more carefully, just differently. The way a woman walks when she knows what is beneath her feet and has stopped being afraid of what anyone standing above her thinks they own. The door her father had locked was open now. She did not intend to seal it again. Thank you so much for watching until the end. If you love this story, check out the other videos on your screen now. I think you'll really enjoy them. And don't forget to subscribe if you haven't already. See you in the next story.